Well, good morning and welcome to the third webinar in our Spring ThinkHouse programme. This one on procurement follows on from our devolution and Freeport specials. And if you would like recordings on either of those sessions, please do just contact us. And just to flag up too that next Thursday, we'll be running a ThinkHouse with Mind Apples, which is an organisation which specialises in mindfulness, a useful technique that we might want to use to relax and enhance our performance, or if we're struggling to cope with the stresses and strains of lockdown, loneliness, or homeschooling. It is fair to say that when we ran our Spring ThinkHouse programme last year, it was our first fully online programme. And although well received, we actually didn't think it would become a habit 1 year later. Some things have changed. I don't need to show you the fire escapes anymore or to tell you to turn your mobile phones off, but there is some housekeeping. This is a curated webinar. We will be taking questions along the way and afterwards. If you have a question, please raise it with me directly using the Q&A button, which you can find at the bottom of your screen, and I shall marshal the questions accordingly. The session is in two halves, so it is likely we'll have some questions halfway through. However, some things will remain the same. We do aim to deliver our loyal audience with high quality speakers, covering a mixed diet of both regular catch-ups and interesting topical subjects that we think impact on your day-to-day needs or are useful in providing you with wider context of significant legal trends. So as I've said, today's session is on procurement. It's divided into two halves. And first, we will look at procurement law as it currently applies in the UK, following our exit from the European Union. I mean, have we been liberated from the shackles of a Byzantine administration? To what extent have the rules really changed? And what is the impact of our joining of the World Trade Organization's agreement on government procurement? After that, we will look at the government's recently published proposals for reform of procurement law. The government is currently consulting on its proposed reforms and is hoping to simplify procurement rules and offer greater flexibility. So I'd like to introduce you now to our first speaker, who is Alison Richards, who will give us an overview of the current post-Brexit procurement landscape. Alison is a very senior and experienced lawyer in our commercial and projects practice. As a law firm, we're members of the government's major projects panel, and Alison has had significant experience on advising on large central government projects, most recently in the rollout of COVID testing kits, and she regularly advises on public procurement issues. Alison.
Thank you, Michael. And yeah, so as Michael says, I'm going to have a quick look at what the current procurement regime looks like in our post-Brexit era and the extent to which things have or haven't changed. So if we can go on to the first slide, please. Lovely. So as you're all aware, so on 31st of December 2020, the EU-UK transition period ended. And on the 24th of December, only a week prior to exit, the UK and EU reached agreement as to what the trade arrangements will look like under the post-Brexit regime. Those arrangements are set out in the UK-EU Trade and Cooperation Agreement, or TCA, and you'll see I've included a link. The slides will come out to you later. So there's a link to the TCA. And then within Part 2, Title 6 of the TCA, along with an annex, which is PPR OC1, it sets out actually what that means in terms of procurement arrangements. Notably, the arrangements expressly incorporate the World Trade Organization General Procurement Agreement provisions, or GPA. So in terms of applicable procurement law, we now need to look at the World Trade Organization General Procurement Agreement, the regulations as we know them, so PCR, the utilities, concessions and defence and security regulations, and of course the guidance. And I'll say a little bit more about some of the guidance that's been issued, and no doubt as things start bedding down, we'll expect to see some further guidance. But that isn't everything, because the government is, of course, considering changes to the UK procurement regime, and Robert's going to sort of let you have a bit more detail about what's going on and what's in the spotlight in the second part of the session. We can go on to the next slide. So before I leave the detail of the TCA entirely, I thought it'd be useful just to share how the TCA deals with EU-UK procurement after Brexit. Again, so I've referred a couple of times to Part 2, Title 6. The document's a huge document, so for those of you that are interested in having a look, if you skip straight to page 148, that's where the 19 articles start, and you can sort of take a look in your own time. The topics of the articles look familiar, just looking down the list, and these are the first 10 on this slide. You'll note that the themes closely follow the principles previously set out in the directives, and indeed covered under the procurement regs. There's very few differences, but what I would say is the provisions aren't prescriptive. It sets out or leaves the detail to be sort of panned out in local regulation. So, for example, under PPR03, which talks about the use of electronic means of procurement, rather than going into the mandatory text that you see in the regulations, it requires electronic tendering to be used to the widest extent possible. And in PPR 08 regarding selective tendering, the UK's agreed to ensure there's sufficient bids to ensure genuine competition without affecting the operational effectiveness of the procurement system. How we go about that is left for the UK to decide. But of course, in the current regulations, we know that there's, for the different procedures, it sort of mandates that you need sort of a minimum number of bidders for different procedures. But it does perhaps give some scope of flexibility for change sort of in the future. So again, popping over to, we'll just look at the next slide, which lists the remaining articles. And again, so under PPR OC 11, the domestic review procedures, this requires each parties to adopt measures to protect the interest of potential suppliers, including, for example, through standstill procedures, or allowing for corrective actions where there's a breach of the rules set down. But again, very light touch, and the details left for domestic regulation. So although fairly sort of high level, the reality though is that the EU and the UK remain bound by the requirements of the GPA. So let's have a quick look at what the World Trade Organization requires in terms of the procurement agreement. So in terms of the structure of the agreement, there's 21 parties to the agreement, and that consists of some 35 members. And although the UK is now a member in its own right, that's little change, because of course we were previously a member, but that was through our membership of the EU. So the first part is the text of the agreement, and it applies to all parties, and it includes obligations around open, fair, transparent conditions of competition, and that has to be ensured across government procurement. And then when you go to the activities covered by entities listed, so that's our equivalent of contracting authorities, their court, so in relation to purchasing the goods and services that are listed in the GPA, and when they're above the thresholds covered by the agreement. again, there's a link if you want to sort of delve a bit further down into that agreement. Part 2 of the GPA is party specific, so there's a UK specific part, and it basically lists the entities that we're a court within our party agreement, so our contracting authorities, and lists the goods and services as well as our thresholds, any exceptions to compliance, and requiring all suppliers to be treated equally and fairly through competition, and that of course mirrors what we're used to seeing. The GPA is administered by the Committee on Government Procurement, although really the enforcement is via domestic law, and there is a World Trade Organization dispute mechanism, but it's been very rarely used in particular in relation to procurement. So our own mechanism continues to apply. And popping on to the next slide. So this looks at how the UK has implemented the terms set out in both the GPA and the TCA, and that of course is via the regulations that we know and love. So we have now implemented the Public Procurement Amendment Regulations 2020. Again, there's a link there, and that revises the existing regulations. But the effect of the changes that have been made are to sort of make fixes. So it fixes the regulations by reflecting the UK's departure, by removing references to the EC. It's fixed references to the EU. There are still some remaining where there's a comparison, but where to the extent it can, it's removed those. It also refers to the new find a tender service rather than overdue advertising. And again, I'll come back to that because there's been some further guidance around that. And importantly, it also confirms that the existing ECJ case law continues to bind our courts until it's overturned, and that'll be either through further legislation or through further case law that overturns previous decisions. And it also confirms that the GPA is the basis for access for EU-based economic operators. Go on to the next slide, please. So the next slide deals with the transition arrangements, and the amendment regulations provide that for all procurements commenced prior to 31st of December 2020, they continue to be governed by the EU directives. Also noting that eCertis continues to be accessible for 9 months, and requirements for reports to be made to the European Commission have been removed and replaced instead with requirements for notifications to be made via the e-notification service. Other changes provide a little bit more clarity around the thresholds that apply. So if we pop onto the next slide, we can look at the thresholds. They haven't changed, although Regulation 5 has been simplified. So rather than referring to the directives and to euros, the regulations now expressly state what the thresholds are in sterling values, and they're set out on the slide. So I don't intend to go through those. But safe to say that the Cabinet Office going forward is going to be responsible for reviewing and revaluing those financial thresholds. But of course, that doesn't mean there's freedom for all, because of course they do still need to align with the GPA thresholds. And we also understand that the first review is due in January 2022. So no doubt towards the end of this year, we should be getting notifications letting us know what those thresholds are going to look like. So I'd now like to sort of start looking at the some of the guidance that's out there. So if we could hop on to the next, perfect, thank you. There's been a few recent procurement policy notes. The first that I'll mention is 10 of 20. Now that addresses the changes to the procurement regime post-Brexit, and it confirms really much of what I've said this morning around the GPA and treating suppliers fairly, and the supplier access to other markets in or under the government procurement agreement. It also contains some useful guidance in the form of frequently asked questions, and you might want to take a look at that. So it goes through a few, maybe sort of 8 or 9 pages. There's some useful snippets in there, and again, I've included a link to the policy note in case that's of interest. We step on to the next one. So the next one I've mentioned briefly already is PPN 8 of 20, which is the find a tender guidance. So this is a new service, so it confirms for all procurement launched after 31st of December, contracting authorities are required to publish your notices on find a tender rather than through OJU. But where a procurement was launched prior to the 31st of December, you still need to continue to publish your notices on OJU, and that includes your contract award notices plus your amendment notices, any corrigenda, etc. We've had a little bit of a sort of a chat with clients to see what their recent experience has been of that service, and understand the look and feel of the find a tender service is very, very similar to the OJU TED service, but you do need to pre-register, and you might therefore want to consider doing so sort of earlier, so that at the point at which you're ready to start placing new notices, then you haven't got the sort of hassle of having to register in that way. That said, we do understand as well that the transition has been very seamless, the system's working wonderfully, and no issues to report, which is all great considering it's only been up and running for a very short time. The PPN, actually, could we just pop onto the next slide? The PPN also confirms that for contracts awarded under frameworks or dynamic purchasing systems, again, if they were launched prior to the 31st of December, the old regime applies, and they continue to be caught under OJU, so that continues, and that includes and extends to call-off agreements and contracts awarded under dynamic purchasing systems. If they were launched after, of course, you're home and dry, so you just stick with the find a tender service. And another couple of things that I picked up from some of the guidance is there is a request that even if you are required to advertise under OJU, there's a request that you also advertise through the find a tender service, so that there's only a single portal for UK suppliers. And I also picked up that you still need to continue with Contracts Finder, and there isn't a link between the Find a Tender and Contract Finder at the moment. Okay, so if we just go on to onto the last slide. So I'd like to just mention PPA 11 of 20. Now, it's not directly related to what we've been talking about this morning, which is the what the regulations look like, because it deals with below threshold procurements, but it is relevant because it deals with the rules around reserving contracts and allowing contracting authorities to reserve for example, SMEs or by specific locations. But it is quite clear that contracting authorities can't reserve procurements for suppliers in the UK or England, Scotland, Wales or Northern Ireland. and it also prohibits reserving contracts if there's a cross-border interest. So this makes it clear that the EU should not be discouraged from participating in UK procurement, and that's consistent with GPA obligations that apply to any other parties to the GPA. And that message is also reinforced, I note, in I mentioned the frequently asked questions to PPN 10 of 20. There's a question around that, and that confirms that we can't treat Europe any differently to previously. So that's all I wanted to say about what the regime looks like now. So I'll hand back to Michael. Thank you.
Oh, thank you, Alison. We have a couple of questions for you. This one is from Fiona Adams, who's been advised that when referencing what's going on in tenders, that she should use the PCR 2015 reference, the Public Contracts Regulation 2015 reference. I'm just wondering whether instead it ought to be a reference to the amendments, as the amended version, as opposed to the 2015 version.
Yeah, so the regulations are still valid, and it's not wrong to say 2015. I mean, as lawyers, we tend to sort of take a belt and braces approach and put as amended afterwards, and I don't think that would be wrong either. So yeah, going forward, perhaps that's the takeaway, as we say 2015 as amended.
Okay, and there's a question here also around future EU decisions, which would, how influential do we think that future EU procurement decisions will be, both on UK practice but also on World Trade Organization practice?
Yeah, so I can't see that they will be anything other than influential. So as I've said a short while ago, the European case law will continue to apply until the point at which it's overwritten by something, or by new law or by new case law. And I can't see that the courts would just disregard that any of the rules that persisted prior to our exit until we have substantially different regulations.
Okay, and then just two more questions, and then I think we'll go into the next session, although we can pick up other questions on this session after that as well. A question here around the Scottish public procurement regulations, obviously, which I know you understand in great detail, Alison. Do the amendments apply to those as well? Do we know?
There are separate regulations for Scotland. I have to, hands up, I didn't look to see whether the amendment regulations amend those two. I'd have to take that away, but I'm happy to come back on that.
Yeah, we've just got funny enough, we've just got another question coming on Scotland, so maybe we ought to do a little bit of BAD after the event on that. And just on, whilst we got the last slide up, just a question as to what's the difference between 1 and 3 on the last slide. The reserving.
Yeah, so of course, so what the PPN says is that if you've got a region of the UK, so there's an example in Birmingham, if there's a big event taking place, you might want to reserve certain services for a particular market. Because of the nature of the service, but you couldn't just, so it'd be fine to ring fence the procurement as long as there's no cross-border interest in those circumstances, but you couldn't say only UK or England suppliers could apply. Okay.
I think, Robert, if I may, I will take this last question because it links in nicely with the fact that we're looking backwards, not forwards here. So this is from the enigmatically named JS. Where, if anywhere, are the old treaty principles captured for those matters that are below the threshold tenders?
Well, the below threshold are obviously not caught by the regulations, except of course they continue to be bound by, you know, the principles around equal treatment. They are now embedded into the regulations. They reflect the World Trade Organization requirements, which is, you know, that'll be why they were in there in the first place. So again, it's one of those examples of where we've had European procurement regulations previously. Actually, they still reflect our position, either previously collectively and now on our own as a member of the World Trade Organization General Procurement Agreement. That's as is.
Okay, thank you very much. And if we could go to the next introduction slide, that would be helpful. Thank you. So we've now got our feel for the current landscape. So it probably now's the time to why stand still? Let's look forward to the government's proposals for future reform. And the government has recently published a green paper called Transforming Public Procurement. And Robert Breedon is going to examine its key proposals. It talks about, obviously, every pipe dream, simplification and speed. A sunny bureaucracy-free upland, unleashing procurement's potential is probably how it's snappily phrased. And talking of sunny, Robert is head of our commercial practice, and he co-leads with me our government sector team and heads our public procurement group. He has significant experience of advising a wide range of government clients on procurement and commercial issues. And his experience includes working actually for quite some time, a number of years, as legal counsel for a central government unit. He will also be sitting on a panel alongside Lord Agnew on the next Whitehall and Industry Group meeting on the 11th of March. And the topic there is procurement after Brexit, and we're very pleased to be sponsoring that event. Lord Agnew's team is actually the team that produced the green paper that we're looking at this morning. And if you'd like details and would like to get involved with that, please either contact us or contact Whitehall and Industry Group for further information. Robert, so what's coming down the tracks?
Thank you, Michael. So if we go to the first slide, just to set out the structure of the next 20 minutes or so, we're just going to look at the background to the paper and the proposed timetable, and you'll be pleased to know we're still in time. It's still possible for you to contribute to the debate around the proposals in the green paper. And then looking into the paper itself, we've separated it into two halves, really. The process changes, those changes that are proposed around the procedures that we will follow and the regulations. And then secondly, the important area of litigation and remedies. The UK has the dubious distinction of being the second slowest and second most expensive system in the EU when it comes to bringing procurement law challenges. I haven't actually been able to find out who's the most expensive and the slowest, but it's not a good place to be, and there are some good examples from around Europe as to how that might be improved. So if we look first then just at the background to this, without wanting to reopen all of the debates around Brexit and the wish to leave Europe, it's quite clear that the government, seeing itself free from the shackles and constraints of EU regulation, wanted to overhaul really the UK public procurement regime. The Prime Minister back in 2019 talked about building a very large bonfire of the red tape that comes out from EU procurement regulations. So some reasonably strong language coming out of that, and it flows through into the green paper. So there's an extract from the foreword there from Lord Agnew. For too long, modern and innovative approaches to public procurement have been bogged down in bureaucratic, process-driven procedures. We need to abandon these complicated and stifling rules and unleash the potential of public procurement so that commercial teams can tailor their procedures to meet the needs of the market. Not often that you hear public procurement and unleashing potential in the same sentence, but there we are. That's a view of the desire and the appetite and the frustration, I suppose, that some feel with the EU regulatory backdrop. So the aims there at the second bullet point: simplification, greater flexibility, an important principle that we'll dwell on later around transparency, a slightly different approach to value for money. So rather than just being quality and price, we're looking to broaden that and to bring into play other factors such as social value and environmental issues. And as we've mentioned, faster and cheaper procedures for bringing challenges, and in relation to remedies, a much greater focus on pre-contractual remedies. So that's the, if you like, the landscape. So the paper was issued, as we've said there, December 2020. The consultation is still open, and we have the ability to respond by the 10th of March. We will certainly be responding as a firm. I know some of clients who are on the webinar this morning are also pulling together some of their thoughts, and we'd be happy if anyone wants to feed into that to reflect your views as part of our own response. The paper is to some extent quite high level. There are areas where, as procurement lawyers, we're itching to get into the detail. You know, what will the regulation say? And I understand why that's the case at this stage. But it's in a couple of areas. It makes, if you like, sort of constructive feedback on the proposals a bit difficult, because you just want to see the details. So we'll bear that in mind as we go through. And the other key factor, of course, is as Ali has just outlined, notwithstanding our desire to radically reform procurement rules, we still have to operate within the constraints of the World Trade Organization's GPA. And of course, at the heart of the GPA is the fundamental principles that opportunities should be advertised, bidders should not be discriminated against. You need to follow a fair and transparent process. So within that context, the government is looking at what it can do around flexibility and speed. Some of the proposals are quite bold, particularly around streamlining the process and more transparency. So we'll now go and look at the first of the process changes on the next slide. So the first real change is that the government's proposing to rationalise and clarify the sets of different rules that we have in place at the moment. So as you'll all know, we currently have the public contracts regulations, we've got the utilities regulations, the concession contracts, and the defence and security regulations. They're to some extent they're broadly similar, but there are sufficient numbers of differences that each time you come to look at the regulations, you can't make any assumptions, for example, that the UCR matches the PCR. So it does entail a little bit of check and referencing across. And what's being proposed is that we'll merge all those into a single set of regulations. And the intention is to lift some of the greater flexibilities that we currently have under the utilities and the concession regulations. Now, they don't go into specifics, but to give you an example of a greater flexibility under the utilities regulations, when we get asked to advise on contract modifications, which is one of the most common questions we get asked on, under the PCR, some of the safe harbours for making modifications are subject to a 50% threshold, so you can't increase by more than 50% of the contract value. You don't have that in the utilities regulation. So that might be an example where government's talking about greater flexibilities offered by those regulations. What it paper also then says is, but there will be specific parts of these new regulations that apply to particular sectors, so defence and utilities, and I suppose critics of this have said, well, it's all well and good having one set of regulations, but then you then supplement it, albeit within the same document, by particular provisions dealing with defence and utilities. So is it really that simplified? And until we see the detail, we won't really know. But at least we'll have just one place to go in terms of looking for the relevant provisions, and some of the process and sort of operational matters will hopefully be more consistent across all of those sectors. So that's the first of the process changes. The next slide just picks up on a proposed change around the types of procedure that will be proposed. So at the moment, you'll be familiar that we have the open procedure, restricted procedure. For more complex arrangements, we have competitive procedure with negotiation, competitive dialogue, and we've got the innovation partnership procedure. So lots of different procedures. The proposal going forward is that we simplify that, and essentially we'll have two procedures for competitive procedures. The first of those is the open procedure. Much as it is today, it's going to be used for simpler off-the-shelf competitions, a sort of one-stage process where you invite proposals against a requirement and some contractual terms. You evaluate the bids and you award the contract. The main procedure that the main change in procedures is the new procedure called the competitive flexible procedure, and that will replace the restrictive, the dialogue, and the competitive procedure with negotiation going forward. And the key features of this procedure, it's very similar to the light touch regime, and so contracting authorities will be given greater discretion on how they run the procurement. And those of you who are familiar with the light touch regime, I think will probably welcome this proposal. We do a lot of work in, for example, in the health and care sector and the education sector where they use the light touch regime. And I think it's quite helpful to be given that greater flexibility. And at its simplest, what the light touch regime says is that opportunities should be advertised. The procedure that you're going to follow and the criteria that you're going to use must be set out in the documentation. Having set it out in the documentation, you must do what you say you were going to do. You need to comply with the underlying principles of fairness, transparency, and non-discrimination, and any time limits in the procedures should be reasonable. So that's sort of high-level, fair process, but within that, much greater flexibility as to how you might run the procurement. So, for example, if you feel that you want the ability to negotiate at different stages, to step down the number of bidders, all of that is into the melting pot. So much greater flexibility and free from the constraints that we sometimes feel frustrated with. For example, no ability to negotiate under the restricted procedure, and subtle differences between competitive dialogue and the competitive procedure with negotiation. So all of that gets, all of those challenges get removed. So that's a key one to look out for going forwards. The third area on this slide in terms of process is what they're now calling the limited tendering procedure. Essentially, this is the direct award ground. The limiting tendering procedure is the language that comes out from the GPA. And what the paper says is that they're largely going to mirror the existing grounds in Regulation 32. So there's only one supplier out there, or for protection of intellectual property rights, extreme urgency, and there's a new ground to be used in cases of crisis. And so this has very clearly arisen from the events of the last 12 months and the challenges that the public sector has faced in dealing with the pandemic, and the need to just get on and award short-term contracts to be able to deal with the particular crisis that we're facing. And so the paper says that government reserves the right to declare a crisis, which would then free up the ability to use the direct procedures. If on a local level there's a local crisis, then the local contracting authorities can apply to the Cabinet Office to say, can you declare a local crisis, which then free up this ground under the proposed rules. A word on crisis, and this will come out in the slides when we send them out to you. It's proposed that this would be an event which clearly exceeds the dimension of harmful events in everyday life, and which substantially endangers or restricts the life or health of people, or where measures are required to protect public morals, order, or safety, or finally, where measures are required to protect human, animal, or plant life or health. So crisis could be triggered, it would be declared, and that would open up the ability for contracting authorities to use this particular procedure for direct awards. If we go on to the next slide, then we've got another of the process changes around what the Green Paper calls purchasing tools, and here they look at dynamic purchasing systems and frameworks. Of all the areas in the Green Paper, this is the one that's the hardest to follow, and indeed Sue Arrowsmith, procurement expert, describes this section as having a lack of clarity and reasoning on these recurring purchasing mechanisms, and that, she says, makes meaningful consultation in this area a bit difficult. I think I share that because I've read it a couple of times, and it's not entirely well developed. But the proposal is that we'd have a DPS system, Dynamic Purchasing System Plus, as they're calling it, to replace the current DPS. It would have no maximum duration, but the duration would need to be set out in the procurement documents. It It is a live system. It's dynamic in that sense, and suppliers can apply to join at any time. And unlike the current arrangement where you're limited to common goods and services, sort of commodity type products, it could be opened up to a much broader range of services. What's not entirely clear from the Green Paper is how you come to call off from the DPS. And the proposals in the Green Paper talk about, well, having got onto the DPS, the way the contracting authorities would then work would then be to use the competitive flexible procedure to invite all suppliers on the DPS to put forward proposals. Now, that doesn't feel at first sight like a streamlining of the DPS arrangements that we currently have. So it feels like a sort of accredited list, and then you go to all of them with this competitive flexible procedure. So I think there's a bit more thinking needed around that. In relation to frameworks, some proposals here, probably not a significant change in what we've currently got. The main change here is that for some frameworks, the current restriction of 4 years in terms of duration can be extended. You can go to up to 8 years, and if you do that, you have to open up the framework. Now that isn't an always open issue, a bit like the live DPS model. It is a framework whereby at points in time, you would open up the ability for other suppliers to apply to join the framework, or indeed existing suppliers on the framework to refresh their proposals in terms of pricing. So a proposal for longer frameworks with the opportunity to reopen the ability to join them at fixed points. Direct awards under frameworks as they are today would be permissible, provided that the objective criteria are set out in the framework documents. And then finally, in relation to the process changes on the next slide, there's a theme runs through the paper around political priorities. It's very clear that the government's proposals say that procurement should be used to underpin and support national priorities, government priorities. And so the proposal is that there'll be a national procurement policy statement issued by government, and that will set out some key principles that contracting authorities will be expected to comply with in running their procurements. And examples given in the paper are there might be a greater emphasis in running procurements on creating new business, new jobs, new skills in the UK, improving supplier diversity or innovation and supplier resilience, or tackling issues such as climate change and reducing waste. So there could be a greater emphasis put on central themes and central objectives around government, and authorities would be expected to comply with that as part of their procurements. And then I mentioned earlier on in relation to value for money, currently you'll know that the rules say that when you apply criteria to determine who is your preferred bidder, the criteria must relate to the subject matter of the contract. And it's proposed that we might broaden that so that you can open up to economic, social and environmental outcomes, as well as considerations around suppliers' records around prompt payment and achievement of environmental targets. So broadening that concept of value for money. Finally, in relation to process changes, and this is a significant change in relation to transparency. The paper talks about transparency will be embedded in our procurement regulations by default. So transparency is embedded by default. Much more requirement to publish information. So publishing notices in all but a few cases, including, for example, modifications and variations to contracts. At the moment, there is a requirement to issue a modification notice for some contract variations, but not all. And so there's a much greater push for transparency. Most significantly, that final bullet, greater publication of information before the contract award and standstill period. So at the moment, as a procedure is concluded just before contract award, as you know, the bidders will receive their debrief letters and we apply a standstill period. At the moment, that just says these are the scores you got, these are the relative characteristics. The proposal is that bidders will get a lot more information, and the paper refers to the sorts of information that you currently pull together in your Regulation 84 report. So some of the background papers that led to the options around the procurement, some of the presumably a lot more information around why you chose the particular type of procedure you did. More information, I'm assuming, around evaluation and some of the feedback there. So push for greater transparency, and this links into the remedies that we're going to come on to talk about, and how that should streamline the process around seeking remedies if you're unhappy with the outcome, and reducing costs. If we have a concern, and we're talking about this within the team yesterday, is might this be a stage now in the process going forward where there are going to be some delays, because as a contracting authority on the threshold of issuing all of this information, might there be a temptation just to stop and double check and be very careful about what's going out, knowing that this is the point where the challenges are going to come, and we're going to be giving much more information out to bidders than we have traditionally done in the past. So this is going to be interesting to see how this evolves, and whether it achieves the desired outcome of streamlining the process, reducing delays, and keeping costs down. So I think that's going to be an interesting area to watch. And of course, for suppliers on the webinar this morning, this will be invaluable information for us to be able to look at and examine and really get under the skin of the reasons for why the decisions have been made and the bids have been evaluated in the way that they have done. So the final couple of slides then, the first dealing with litigation and remedies. So firstly, the proposal is that we set up a new unit within government, almost certainly within the Cabinet Office, with responsibility for monitoring public procurement and intervention where necessary. So this is building upon the Public Procurement Review Service that is currently in place. It used to be called the Mystery Shopper Scheme. So the PPRS will be replaced by a new unit with greater intervention powers. And the paper unashamedly says this is about driving up standards in the public sector, about driving up the standards in contracting authorities. So the unit will reserve the right to intervene and say that's just not good practice. Let's do it differently. Let's start again. And then when it comes to the remedies itself, if you're an unhappy bidder, you're unhappy with the process that's been followed or the outcome, the proposal is that we'd have a tailored fast track system within the Technology and Construction Court. And I think most of us, looking at the way the Technology and Construction Court has operated in recent years, we think they're doing a good job. That it's great to have judiciary that are really expert in and understand public procurement law, but it is too expensive and it is too slow. And they've looked across Europe and they think that we could do things in a more streamlined and efficient way. And there's an interesting proposal that you might even have some cases just decided on written submissions. There's a particular barbed comment that the advantage of this would save the parties employing expensive barristers. It may explain why some of these proposals have received a bit of a lukewarm response from members of the bar. A greater emphasis on pre-contractual remedies. I mentioned earlier on, before the contract is awarded, you'll have much more information and the ability to bring a challenge at that stage. And the paper is strong on the remedies at this stage might be, well, rerun the procurement, set aside the decision, correct the errors where there are obvious errors on the face of what has been disclosed. And the paper says there's no reason to assume that damages is the remedy that suppliers are looking for. And the paper references a lot of feedback that they've had from the supplier base, that actually they're more interested in the opportunity to win the bid and secure the contract than they are in recovering damages. So will we see a shift in that remedial landscape, which is away from longer remedial processes and awards of damages to something which is faster and slicker? There is a new tribunal service that is also mooted for some smaller claims, and the paper says that if the proposals for the TCC don't bring around the benefits and advantages that are proposed, then they'll push more down into that tribunal stage. And then our final slide on litigation and remedies is, because the emphasis now is on pre-contractual remedies and rerunning the procurement or correcting the errors, the paper says that there should be less emphasis on damages. And the proposal here, reasonably controversial, I think, is that the damages will be capped. at the legal fees that you've incurred and a multiple of the bid costs. So by no reference to the profit that a supplier would have earned under the contract. And the paper says that is aimed at reducing speculative claims. And we can have all sorts of interesting debates about how that fits in with the usual sort of UK law principles of you should be put back into the place that you were. But so a cap on the available damages that you would recover. There are exceptions for that. Not surprisingly, it would be inappropriate to cap the damages where you don't have the opportunity to challenge the award before the contract is entered into. So if you're into the territory of illegal direct awards, crisis procurements where no notice has been published, then clearly you should be able to come along, and if you recover damages, they wouldn't be subject to the same cap. And then a couple of procedural points at the end here. As a result of the proposals around urgent and crisis contracts, there'll be no automatic suspension. If a challenge is brought, that wouldn't suspend the contract. The authority will be allowed to carry on with the contract that it's awarded for dealing with the crisis, and you pick up presumably as part of a damages claim further down the line, but not an automatic suspension for those contracts. And as a result of the greater transparency, greater information that we will see at the standstill period, the sort of mandatory debrief letters that we've got used to will disappear, and again a reliance on the greater transparency before the contract award. So final slide, and just some key takeaways from this morning before we open up for some questions. In relation to Ali's section there, just a reminder there, need to update the procurement templates that you're using to reflect the updated regulations and some of the terminology, such as the reference across to FTS and the finder tender service. And in relation to that, we'd encourage you to register for that, get on board early rather than doing it the day before you want to get your notice out, just so it's all set up and ready to run. And we'd encourage you to participate in the consultation process. Say the deadline is the 10th of March. You can do that directly, as I know a number of you are, or if you wish to, you could feed some observations and comments through to us. So I'll hand back to you, Michael, at that stage.
Thank you, Robert. You've stored up a hornet's nest. There's a few questions coming your way, which is
okay.
Which is really interesting. I guess just a sort of high level question, with your experience and also the experience of the very experienced people you're talking to as well. What's your general sense of excitement around the green paper? Are people saying, yes, this is at last, we've finally got a process we think is going to work, or is it a bit more muted than that?
No, I think the proposals have been broadly welcomed, and I can see why. I think there is a simplification in there around, particularly I think the single set of regulations and the reduced number of procedures. Whether I think there's a little bit more, there's a bit more doubt about whether the remedies procedures will really be simplified and speeded up, or whether we're just going to find, will we recreate some other dispute process around earlier pre-contractual remedies? Might we get bogged down in that pre-contract stage? We might just be bringing forward the current debates to a slightly earlier stage in the procurement process. That's my slight reservation around that, but I think the simplification of the procedures is very welcome.
I mean, just picking up on the thing, one of the questions is indeed, do we think challenges are going to not just come earlier in the process, slowing the process down perversely, but do you think we'll just get more of them? Is it easier to challenge?
Probably. I think that will all turn on the scope of the new tribunal when it's introduced. So if you're in smaller claims and it's a fast track procedure, then yes. If it's going to be easier and cheaper to challenge, then why wouldn't you? I think the counter argument to that is, well, if we're being much more transparent about the process that's been followed and the reasons for the evaluation scores that have been given, maybe that transparency will result in a greater level of satisfaction or explanation that unsuccessful bidders have, and maybe they'll feel less inclined to challenge if they're getting the full information, because there's no doubt that some, at least early requests for information and informal challenges come from not knowing, not having that full information. And a couple of years ago, many of the people on the webinar will understand that the TCC put out guidance on encouraging us to be much more open around disclosure of information, and this is just taking it to that next stage. I still think there's a tendency to hold back on information because of that worry that it will generate a challenge. It may be the case that that greater transparency opens up, gives a greater understanding, and therefore it may be that challenges reduce. So in theory, I could see that it would increase because of the simplicity of it. So.
Thank you, Robert. I mean, it's a good exam question here coming from Mark Ridge. So get pen and paper ready, Robert. So it's in relation to open frameworks and how they might work, and particularly in circumstances if you had several lots with a manageable number of suppliers on each, say 6, would you have to open up the application to new and existing suppliers?
Yes, it's a good question, and what the paper says there is that so it might be closed for a period of time, and in that example that Mark's raised, you might have six suppliers on there. When you come to your 3, 4, or 5 year point, whatever it is you've said you're going to open up the framework, you need to give the opportunity for not just new suppliers to come on and show that they meet your requirements and are deserving of a place on the framework, but also the existing suppliers who might take the opportunity after 4 years, for example, to refresh their pricing. The risk for suppliers who are on the framework who do that is that they run a risk of being replaced by the new supplier. So if you might want to limit the number of suppliers on your framework to 6 or 8, and once that number is determined, an existing supplier runs the risk of being pushed off of the framework. So it just opens up a bit of a competition at that later stage.
Thank you, Robert.
And picks it up.
Yeah, that's perfect. Yeah. And two final questions, just I think sort of finger on buzzer type answers. So will the replacement to the mystery shopper, this is from Fiona Adams, will the replacement to the mystery shopper be likely to have a wider authority than the guidance Cabinet Office would currently give?
Yes, we don't know the detail of it, but the paper expressly says that it's building on the current PPRS mystery shopper scheme, giving greater powers to intervene. So I think it's going to have that, because at the moment what the PPRS does, it will contact. So if a concern is raised by a bidder during a procurement process, PPRS will contact the contracting authority. It will ask it to explain the process it follows, but it doesn't have any real teeth beyond then publishing in its quarterly report what it's found. So after the event, the authority might find that it's been named in the quarterly report, and the PPRS might say, we think this better practice might have been followed. Now, in practice, of course, what happens, simply having that conversation can cause the authority to stop and think. But I think going forward, the new unit, as yet unnamed, would have actually the power to intervene and to direct a change in the process. So.
And then probably a great place to finish with, this is another question from Fiona. In your current view, when are the new regulations going to come in following the Green Paper feedback? 2022 or
yes.
we're going to have a big launch alongside the Commonwealth Games of the procurement regulations? I don't know.
Who knows? I suppose it rather depends on the nature of the feedback they get. If they're getting broad support for it, they might well push ahead with it. But I'd have thought 2022 was a reasonable expectation. Obviously, government has quite a lot on at the moment in dealing with all of the stuff post Brexit and the pandemic. But there does feel to me as if there's a bit of momentum behind this. It is a topic that gets people quite exercised around the whole bureaucracy, and it would be seen, wouldn't it, as post Brexit one of the key changes that that would have been made in terms of the sort of move away from the European influence. So I could see them wanting to move ahead with it.
Yeah, very, very good point. That last one, it's quite totemic in
yes.
that sense, isn't it? Yes.
Yeah.
Okay. Well, just to say, if you want to hear Robert talk again, why would you want to? But if you do want to hear Robert talk again, he'll be speaking with Lord Agnew at the next Whitehall and Industry Group session on the 11th of March. If you want details, of course, please contact Whitehall and Industry Group or ourselves, and we can send you through. And just to remind you that next Thursday we have our Mind Apples session on mindfulness. If you want a bit of a break from the grind of lockdown. But it just leaves me now to thank both Robert and Alison for a fascinating look at new law and even newer law coming down the tracks, and also behind the scenes, Susie and Dipali for putting this webinar together. But finally, a big thank you to everyone who's joined us, and I hope it's been enjoyable. Thank you very much indeed.